The judgment didn't say that elections must be held within 90 days. If it had said that and left it at that, it would have been a far simpler matter. Just as if it had been a full court deciding, it would have been a far simpler matter. And today's de novo hearings or review hearings or implementation hearings wouldn't have been necessary. The judgment instead said that's what the Constitution says, 90 days, and the minimum deviation from which is permitted. The ECP then used this minimum deviation line to create a ridiculous deviation of 6 months, according to some reasoning and rationale and excuses that they gave. This was a decision that had a minority judgment. Now, I agree with everything Justice Mansoor Ali Shah Sahab has said about everything other than where he comes to the number counting. Because he feels that once a bench is made, thereafter, the chief is not left with any administrative function of remaking the bench. It is instead a judicial function. And then he goes on to imagine that out of the 9, 7 were left as a bench because 2 had recused themselves, and the 2 that were removed from the bench had somehow not recused themselves and passed some kind of final orders, which is debatable in itself because Justice Manilla's order does not read like a final order. Neither does Justice Afridi's. However, the biggest issue with the decision given by Shah Sahab, Justice Mansoor Ali Shah Sahab, is that it wasn't the Chief Justice that decided to reconstitute the bench. There is a 9-member signed order of the bench which allows for the Chief Justice to reconstitute the bench, meaning that once the bench was reconstituted, this process started de novo, it started afresh, which is why I humbly do not agree with what Justice Shah said. Now, coming to the effect of what he said, and I agree with almost with everything else he said, and I think it's a superlative use of judicial analysis, and I think especially his reading of Article 199 with 183 to preclude the Supreme Court's right to review other than by way of appeal a decision given by the Lahore High Court, which was the case here. So I think a very strong case has been made out for why the Suo Motu should not have been initiated, and instead why at best directions should be given. But in this numerical thing, I think it falls short of the facts as they then were. The effect of it, I think it will further the divide in the court. I think its timing is such that it will necessarily add to the government's repertoire of weapons against the court. I think the government will use it to try and pressure the court, and I think the court hasn't learned its lessons, and it did not put up a full court again once given a do-over. So I think the court will also suffer from being, whatever the decision these 5 members give, it will also suffer from lacking the legitimacy that a full court would have provided, especially in such a divided time. I think you can't just undo the effect of a judgment, especially where, just because you think you are in the majority, especially where that judgment has been adhered to and now is being reheard or is being implemented by the Supreme Court itself. So it will have little practical effect, but it will have tremendous political effect and pressure effect on the Supreme Court and its functioning. I think Justice Qazi Faiz Isa has spent the last few years being self-critical of the judiciary. He's done it rather well. He's done it through letters that he's put on the public record. I think Justice Mansoor Ali Shah, as the Chief Justice of the Lahore High Court, was very self-aware, was very critical of the judiciary's shortcomings. I think Justice Manilla, whenever he got the chance, was self-critical as much as his situation allowed him to be. I think before that, post the Iftikhar Chaudhry era, I think before 2007 we didn't really have a judiciary. It was a pliant extension of the executive for one reason or the other. But I think in the Iftikhar Chaudhry era, self-criticism was not gone to, because Iftikhar Chaudhry realized that his entire strength was in the unity of the bar and the bench. So criticism was for a further more refined time. But then we pushed this unity too far, and we saw the ludicrousness of Iftikhar Chaudhry and his Suo Motu on sugar and his Suo Motu on 2 bottles of wine that came out of Atika Otto's bags. But this unity had a breaking point, and we found it in Sakib Nisar. And after Sakib Nisar, in the ridicule that it went through because of Justice Gulzar, and now with the Panama hearings and processes, and now with Justice Bandial, his absolute refusal to put a full court where a full court really does belong, is going to further this divide, and it's going to take away from the legitimacy of everything the court pronounces, even if it's squarely within the 4 corners of the law. So self-criticism is the need of the hour, and the fact that it's coming from people like Justice Issa and people like Justice Shah is a portent of better things to come, hopefully, in the future. Dissent is never bad. Dissent, whatever form it takes, whether it is the unrefined dissent that we saw from Justice Afridi in the first round of this election in 90 days case, or whether it is the supremely refined Mansoor Ali Shah Saab version that we see now. Dissent always adds to the debate. It always allows for democracy to flourish where there is previously not democracy. It always allows for the discretion to be fettered, which is the need of the hour. So there is no such thing as bad dissent, but every Chief Justice will tell you that all kinds of dissent is bad. And that is part of the problem, that there is too much power concentrated in one individual, and that individual of late and the individuals before him has been seen to be abusing that power, or at least not listening to the nodal points of society which ought to be listened to when critique is being spelled out.